to the Senate Committee on Human Services. We are grateful that all of you have taken time out of your busy schedules to be able to attend. We have an important milestone here today. It is Mariva's first committee back, and we are so excited that she is back. My goodness. We have missed you. It has not been the same without you, and we are so damn glad that you are back. And you do so many good things on behalf of the people of California, and so happy about the speedy recovery as well. And it is so good to see you back.
And
so,
you look mom.
Absolutely. Oh my gosh. Hot dang. So it is big news for all of us. And I want to say thank you to Taryn and to Mark for holding down the fort as well. And Taryn is new to the committee as Sarah moved on to the department, which we are excited about. And Taryn, thank you so much for all of your work as well. So appreciate working with you. So, ladies and gentlemen, we're moving straight in to our hearing. We have Senate Bill 904 with Senator Hertzberg, who's here today, which is focusing on public social services and CalFresh. Senator, the floor is yours.
Thank you, Mr. Chairman. Members, appreciate it very, very much. You know, CalFresh program, which the members are keenly aware, uses federal dollars to put food on the table of low-income families. And there's somewhat of a challenge in the law as currently written. When there's declared labor surplus or high unemployment declared by the federal government, some counties have the option, it's a local option, to actually extend those benefits to families in need. And what we're doing here is that with respect to that waiver is we are making that no longer an option. We're basically saying that when you have a federally declared circumstance, whether it's a labor surplus or high unemployment, that we certainly want to make sure that those kinds of benefits are extended to families who are in high need. And with us, like Sarah, if you want to start out, witnesses in favor.
Thank you so much. If you could just introduce yourself, please. If you're first and last in the organization, we welcome you.
Sure. Sarah Palmer, California Association of Food Banks. Thank you, Chairman and members of the committee. I'm the Advocacy Manager at the California Association of Food Banks and also a member of the Hunger Action Coalition Steering Committee. We are in support of SB 904 to prevent harm to able-bodied adults without dependents in the CalFresh program when our state waiver of the 3-month time limit expires at the end of 2017. Under this rule, this population is limited to 3 months this population is limited to just 3 months in a 3-year period unless they're employed for at least 20 hours a week or participate in the CalFresh Employment and Training Program. The federal government may waive this rule if a state, county, or part of the county has been declared a labor surplus area. Currently, California has a statewide waiver due to having unemployment rates that are relatively high compared to the national average. This state waiver will end in 2017, but individual counties or sub-county areas with high unemployment may still qualify for a waiver. Under existing law, even if out-of-work Californians are eligible for federal food benefits due to a county or sub-county waiver, a county may elect not to accept the waiver, whereby foregoing federal money for food assistance in times of great need. SB 904 establishes the federal law defining eligibility for federally funded anti-hunger help be applied evenly across the state by requiring all areas eligible for a waiver to accept. SB 904 will prevent hunger and hardship among the Californians when jobs are not available and provide relief to counties from administrative costs of determining the variability of the waiver. According to the federal law, if CalFresh recipients who is subject to the time limit falls short of the 80-hour work activity, the entire month must count toward a 3-month time limit, regardless of the reason for not meeting the requirement of the household circumstances. This means that even if someone is looking for work, unless someone hires them, they can be denied that help and would otherwise be qualified to receive this benefit. The ABOD time limit for out-of-work adults simply increases hunger and pushes them further away from the workforce. SB 904 will help alleviate this impact by ensuring that the rule doesn't apply in areas eligible for the federal government waiver due to high unemployment. Please vote yes for SB 904. Thank you.
Thank you so much, ma'am. I don't mean to interrupt. We're going to take a quick roll while we have a quorum, and we'll get right back to you. I do apologize. Mr. Teamer?
McGuire?
Here.
McGuire here. Berryhill? Hancock? Here. Hancock here. Liu? Nguyen? Here. Wynn here. 3.
Quorum is established. Thank you so much. Please, if you can just introduce yourself and the organization.
Mr. Chair and members, Elizabeth Landsberg with the Western Center on Law and Poverty. We're pleased to co-sponsor and urge your support of Senate Bill 904, which would reduce hunger for out-of-work Californians by requiring counties to maximize the so-called ABOD waiver for CalFresh. Penalizing people who can't find work by making them hungry is really inhumane, and we urge your support for this important measure. Thank you.
Thank you so much.
Yeah, good afternoon. Kevin Aslan, Coalition California Welfare Rights Organizations. What this bill does is implements one of the Department of Social Services CalFresh Refresh provisions, which is that the state will decide which counties get a waiver rather than having 58 counties do it separately. This would be in one shot. The state would do it. It would be easier. It would save money. And we urge your aye vote. Thank you.
Thank you, Kevin. It's a great bill. Thank you so much. Anyone else in support that would like to be able to come forward? Do we have any individuals that have concerns or are opposed? I'll be supporting the bill. We'll be going to Mr. Hertzberg for a closing statement.
Just in 2013, CalFresh moved 890,000 people. Those are people whose lives and hopes and dreams are relying on the CalFresh program above the poverty line and lowered the state's poverty rate by 2.4%. It's an extremely important program. I ask for support of this measure.
I want to say thank you to the senator for all of his leadership on this. So thank you so much,
you,
sir. It's good to see you.
Thank you.
Let's
I
go
would
to-
like to move the bill.
Thank you so much. Just going to ask.
Thank you for your
anyone else?
co-authorship.
Thank you.
Yes, as a co-author,
As
I
a
did the
co-author, I
least I
appreciate
could
that,
do.
Madam Chair.
Mr. Teamer.
McGuire.
Aye.
McGuire, aye. Berryhill. Hancock.
Aye.
Hancock, aye. Lou. Wynn.
Thank you so much. We're going to hold it open. We need one more vote.
Thank you so
I do
much.
Appreciate it. Thank you very much. I'm going to look to Senator, actually, why don't we go to Ms. Mitchell, because I think she has another committee. So we'll go to Ms. Mitchell if that works for you, Senator, if you want to come on forward. And then we'll go to Senator Hancock, who will be presenting Senator Lou's bill, who is currently in transportation. We have Senator Mitchell, who was placement of children regarding criminal background, criminal records check, and this would be a fantastic bill, and I want to say thank you for your leadership, continued leadership on this issue, Senator.
Thank you very much. And I'd like to thank the Children's Law Center for partnering with me on this measure. So today I'm here to present Senate Bill 1201, a bill that will do primarily two things. It will expand availability of placements for foster care kids, and it will reduce delays in relative placements for children in foster care. This bill will address impediments to appropriate relative and foster care placements by conforming state law to federal requirements regarding caregiver criminal history reviews. Specifically, it will eliminate the complex exemption process and will align the list of non-exemptable crimes with those required by federal law. California's current law relating to the criminal history of a prospective foster or kinship caregiver are overly broad and unduly restrictive. Several lists of crimes have been deemed non-exemptable. For all other crimes in which any household member has been convicted, no matter how minor or how long ago the offense took place, or if it's even unrelated to child safety, an exemption must be granted to approve the home for placement. These changes do not compromise child safety. I will repeat that. They do not compromise child safety. California law will continue to prohibit, without any discretion to make exemptions, serious violations, violent felony conviction, no matter how long ago the conviction took place, assault, battery, or drug-related conviction within the past 5 years. Furthermore, the 1215 enactment of Assembly Bill 403 by Assemblymember Stone, that I'm sure this committee heard, requires statewide implementation of the Resource Family Approval, the RFA process. Under the RFA, all foster and relative homes will be required to undergo a psychosocial assessment, which will involve several face-to-face interviews and a thorough consideration of any criminal history of the caregiver or household member. Currently, there are more than 5,800 foster youth living in group homes in California, and as you know, as a result of the administration's continuum of care reform effort, we are scheduled to phase out group homes in this state by January of 2019. Clearly, we must do all that we can to recruit, to expand recruitment efforts, and to expand the pool of qualified, committed foster care homes. As the analysis states, I've offered technical clarifying amendments, which my staff, committee staff, and advocates have worked together to clean up code while adding back a section that was inadvertently stricken when the bill was drafted. Here to speak in support of SB 1201 is Susan Abrams from the Children's Law Center and Judy Simpson, who, as a prospective family caregiver, experienced the problematic delays that current law creates. I ask for your indulgence for their testimony and your aye vote.
Thank you so much. And before we go to the Speaker Center, I want to make sure you're comfortable with the amendments and taking the amendments here in the committee. Yes. No.
Yes.
It's all good. Thank you so much.
As the analysis states, I would, of course, accept Mariva's amendments.
Absolutely.
No question.
Why don't we start with Ms. Abrams and then, please.
Chair and honorable members, my name is Susan Abrams, and I am the Policy Director with Children's Law Center of California. We currently represent the children in foster care in Los Angeles County and Sacramento County, which is approximately 32,000 children in the state. I wanted to start by thanking Senator Mitchell for authoring this important legislation. The problems Senator Mitchell described with the current criminal history exemption process are issues we see frequently and oftentimes to the detriment of our clients. SB 1201 would help to address these issues by implementing a meaningful process to evaluate a safe placement for a child without some of the unnecessary hurdles that exist today. I believe the following three common case scenarios best demonstrate the profound benefits of this bill. First, far too often our clients are placed in the home of a stranger or in a congregate care setting because a relative or family friend available for placement has a petty theft conviction from 20 years ago or a similarly non-child safety related misdemeanor conviction. Many times the social worker, the judge, the attorney, the parents, and the child are all in agreement that the caregiver would provide a safe and stable home for the child, but the child cannot be placed until there is a formal exemption, as one is now required for every conviction. SB 1201 would allow the child to be placed immediately at the outset of a case if, after review of the prospective caregiver's criminal history, the social worker or court deem the placement to be in the child's best interest. Second, a potential caregiver is excluded from even being considered for placement because of conviction that the county agency mistakenly believes is non-exemptable. The current law is extremely confusing. It has a long list of non-exemptable crimes and then cross-references several other long lists of crimes. And I just wanted to give an example. I received an email from an attorney just last week where the child was placed in a different county and the caregiver was a relative caregiver, was granted an exemption. The case transferred to Sacramento, and Sacramento is under the belief that that crime is non-exemptable, and the child was removed from the home, and we're still trying to get the facts of the case. But there's just a lot of confusion around this area. By conforming state law to federal requirements regarding exemptable versus non-exemptable crimes, SB 1201 would simplify and streamline the list of non-exemptable crimes. It would also remove some crimes from the non-exemptable category because they are either non-violent felonies or misdemeanors, such as indecent exposure. These crimes are more appropriately considered on a case-by-case basis rather than categorically precluding placement. The third case scenario we repeatedly encounter is undue delays in placement because of the exemption process. You'll soon be hearing from Judy Simpson, who will describe the trauma that she, her husband, and their grandchild face as a result of an exemption delay. SB 1201 seeks to remedy these delays by requiring criminal history convictions to be considered when all other factors are being considered for placement rather than as a separate process. As a final comment, it is important to emphasize and reiterate the comment made by Senator Mitchell that the changes will not compromise child safety. Rather, they present a sensible approach to the assessment of a prospective caregiver's ability to safely provide a home for a foster child. We urge your support of this significant legislation.
Mr. Abrams, thank you so much.
Thank you.
And Ms. Simpson, I'm looking forward to your words, but do want to let you know that we have support from both sides, so which is really positive on this bill.
Okay. All right. I would just like to say that I'm honored to be here. Yes, my name is Judy Simpson. Our grandson had been placed in foster care in December of 2012. He was 9 years old. His mother abandoned him, then his father abandoned him and dumped him off at CPS. It was over a year before we even found out he had been placed in CPS. Nobody had ever contacted us. Yes, we live here in Sacramento, and this was in LA. However, that's not an excuse. It took 20 months of almost every 2 or 3 months of driving back and forth from LA for court dates and court dates and court dates. Then it finally came down to, well, Mr. Simpson has a record. Okay. He has a record 40 years ago when he was 19 years old for buying a motorcycle at a swap meet, fixing it up, and going to sell it, and at that point in time found out it was stolen. He was arrested consequently for receiving stolen property. 30 days in jail, informal probation. Okay. The only other item they found was in 1993, was a dispute between, at that time, an estranged wife. They got into an argument. She was mad. She was crying. She called the police. The police arrived and said, well, she's crying. You must have done something to her. I'm arresting you. The outcome of that was a misdemeanor, 30 days, 36 months in formal probation. That was in 1993. Nothing since then. He has successful businesses. Between the two of us, we now have 4 businesses that we run. We do a lot of things for the community. We've submitted all kinds of verifications as to what things we do for children, for Pop Warner, for all of this stuff. We just now got custody of him in July of last year after fighting with this since March of 2015. We transferred the case from LA up here to Sacramento because they gave the exemption finally after 20 months of fighting it. Transferred the file from LA to Sacramento County only to find out we had to do it all over again. For 2 issues, one 40 years ago and one in 1993, which was a misdemeanor. Our grandson just turned 13, but because of in and out of group homes, foster care homes, being told, no, you can't see your grandfather, you can't go to visit or anything else, he has now been diagnosed as being a narcissistic schizophrenic child. We have a lot of support finally in place with a lot of arguing and a lot of fighting. But if this process had been shortened a lot more, the severity of his mental issues would not have been as severe. Thank you.
No, Ms. Simpson, you did a great job, and really grateful telling the story of the 40 years and the 25 years, and thank you for sharing about Max as well. We so appreciate you being here. Thank you very much.
Thank you.
That was really
Thank you for your
powerful.
time.
Oh, thank you. Would like to be able to see if there are any other individuals that would like to be able to come speak in support of the bill. Please come on up. If you could just state your first and last name, the organization, and your position.
Angie Schwartz, the Alliance for Children's Rights and Support.
Thank you so much. It's good to see you. Would anyone else like to be able to speak in support of the bill? We welcome you.
Thank you very much. My name is Robert Stevenson. I'm a retired Superior Court judicial officer. I sat for 8-9 years in Los Angeles County Superior Court. I ran into this situation every single day where we had to continue cases, because this process was not completed effectively. Kids sat in foster care. They got bounced from one foster care to another foster care home. So we are, my organization, which is LADL, which is Los Angeles Dependency Lawyers, a nonprofit representing 21,000 parents in Los Angeles County, we support this bill.
Robert, thank you so much for taking the time, sir. Good to see you. Would anyone like to speak in support of the bill? Would like to be able to see if anyone has concerns or are opposed. I'll be supportive of this bill. Let's bring it back to Senator Mitchell for closing comments, please.
Thank you very much, Mr. Chair, and I appreciate Ms. Simpson sharing her very personal, very troubling story. Again, we don't intend to compromise child safety. We think this is a very measured, reasonable approach to a structural bureaucratic problem. Again, recognizing that actions that the legislature and this administration has taken in terms of making the policy decision to close group homes, we therefore have to be very proactive in making sure that there are homes that are equipped and ready and available to take the 5,800 kids who are currently in group home settings. I think this is one step we can take to increasing the likelihood that family caregivers will be available and quickly licensed, particularly for that immediate emergency placement. So with all that, I ask for your support of this measure.
Thank you so much, Senator Mitchell. Is there a motion to approve? Thank you so much. Vote, please.
McGuire.
Aye.
McGuire, aye. Berryhill. Hancock. Hancock, aye. Lou. Nguyen.
All right, right now we have 2 votes in favor. We're going to hold the vote open. We have 1 vote to go. So thank you so much. And we'll let you know as soon as we get the 3rd vote. Thank you very much. Thank you very much. Appreciate it. Thank you again, both of you. Thank you, Senator Mitchell. It's great to see you as always. We're now